Hi, good morning. It's Ken Crotty again, and we're here Saturday, May 23rd. It's a Memorial Day weekend. So, one exciting thing, Memorial Day weekend, we get Monday off, which really, I'm not sure what the difference will be for a lot of people who are working from home. So, that being said, I hope you do have a happy and safe Memorial Day weekend. Take a minute to, think about the reason that we have the holiday and acknowledge the individuals who do a great job for our country and provide a service, as well as those that have obviously paid the ultimate sacrifice for everything that we have. So that being said, what we're going to do today is spend half an hour talking about tenancy by the entireties. So this is a form of ownership, property ownership, that can be between spouses, assuming that certain elements are satisfied. And the benefit of tenancy by the entireties is that if the creditor of one spouse is trying to satisfy a judgment, so if we have a doctor and a stay-at-home spouse, the doctor has a potential creditor claim coming down the road. Any assets that are owned as tenants by the entireties by the two spouses would not be subject to the potential creditor claim of the spouse. That's different than an asset that's owned as tenants in common, and that's different than an asset that the doctor would own individually. So we'll talk about that in some more detail. But this is one of the simplest things that you can do to help provide protection for yourself and or for your clients. And it's also a very easy thing to make a mistake and inadvertently not have tenancy by the entirety protections. So again, going forward, I wanted to just let you know we've got a couple of webinars that are going to be playing next week, both of which will be given by Alan. What clients need to know about bankruptcy, hopefully nothing, but some clients may be in a situation where they need to know more. And so what Alan will do for half an hour is give you some highlights on what to look for from a bankruptcy perspective. It is something of importance. And then Saturday morning, Alan is in his wheelhouse, creditor protection for physicians. So as many of you know, Alan speaks regularly on this topic. So having half an hour of insight from him on key points, both for your personal planning and or for clients and or family and friends, it's going to be well worth the time to do that. We've also got a list of the upcoming presentations. You get a break from me until Thursday, June 25th, and then we'll be sharing Thursdays together, hopefully, and go from there. All right, so a couple of items. We've got the quotes here, number 4 to start, and I know I used it last week, but considering we're talking about spouses, I do really enjoy the Rodney Dangerfield. My wife and I were happy for 20 years, and then we met. We've got a few other ones in here, which you can read. Hopefully it'll give you a little entertainment. It's our version of the Saturday Funnies. All right. So again, it wasn't raining when Noah built the ark. And the reason that we put this slide in here is to talk to you when we do about tenants by the entireties, to recognize how important it is to make sure that the title is taken correctly from day one, because that really is one of the key elements, is that you own the asset as tenants by the entireties between spouses. So going to the introduction, tenancy by the entireties. Frequently, if you're reading legal material, or if we talk about something and we say TBE, that means tenancy by the entireties. It's derived from English common law, and the main presumption is that it used to be husband and wife. Now it's spouses under Florida law, because this is available for anyone who is married under Florida law. So the main presumption is that both spouses own 100% of the property as an indivisible unit. Now, both spouses, either of them have the right to sever the property, but a creditor can't force that. And so what that means is that if a creditor of one spouse is owed money, they are not able to look to any assets that are owned as tenancy by the entireties to satisfy the judgment. The only thing that would stop, or that the protection is not afforded to for tenancy by the entireties assets, from a creditor standpoint, would be a joint creditor. So if a husband and wife decide to take a loan out, or two spouses decide to take a loan out, and they sign a joint guarantee, then because they are both on the guarantee, that could subject their tenancy by the entirety assets to satisfying the judgment. However, if only if you want to think about it, if only one spouse signs the guarantee, then that would not expose the tenancy by the entirety assets to the potential satisfaction of a debt that was owed by the one spouse. If one spouse lives outside of Florida, then you may be in a situation where you're dealing with the law that's applicable for the state. And it's also important to realize that if you look, some states recognize tenancy by the entireties like Florida does, meaning that it gives you a great amount of protection, and it's extremely beneficial to provide you, with that protection from creditors, et cetera. It applies basically to all assets, if not all assets in Florida. Now, if you go to some other states, it only applies to real estate, or it may only apply to tangible property, or in a worst case scenario, they don't recognize it at all. So when you're making investments in states outside of Florida, or if you're talking to a client who is outside of Florida or has investments outside of Florida, that's a discussion that you want to have to make sure that you're not just assuming that the tenancy by the entireties protection here in Florida would apply outside. For instance, and we touched on this last weekend, is that if you as husband and wife bought a property in Georgia, that property is not owned as tenants by the entireties. It's owned as tenants in common, meaning that you own 50%, your spouse owns 50%. And if you have a creditor claim, 50% of that property could be subject to the creditor claim. Now, if you buy property here in Florida as husband and wife, the presumption is that you're going to have that owned as tenants by the entirety. And you might just have bought, numerous pieces of property here in Florida and expect that you would have the property owned as tenants by the entireties. That's going to be a shock to you when you find out that it's tenants in common and now you don't own it with the spouse, but now the creditor is looking at getting a portion of the property. So the workaround for that is to establish a Florida LLC. The Florida LLC can be owned by the spouses as tenants by the entireties. And then the Florida LLC can purchase the Georgia property. Now, the benefit of that is twofold. One, if someone does slip and fall on the property, and there's a creditor claim or a creditor situation, the liability is going to be limited to the assets of the LLC, and none of the other assets would be exposed. But then two, in the event that there's a creditor situation of one of the two spouses, by owning the assets as tenancy by the entireties, the asset's not going to be subject to the individual creditor claim of either spouse. So that's, again, extremely important. A couple of other items on tenancy by the entireties. So this is the portion of the show where if you want to look and memorize this slide, you're going to be able to bore your children, which I'm running out of ways to do, honestly. After 2 months with 3 kids, we're very lucky. They're great kids, 12, and the twins are 9. Our oldest is 12. But after 3 months, there's really only so much you can do to embarrass your children without the help of their friends, because really that's one of the better things about being a parent. So tenancy by the entireties, like we talked about, it goes back to English common time. This kind of gives you the reasoning behind it. And again, just highlights the point that you need to be careful if you are dealing with states outside of Florida. So for the definition of tenancy by the entireties, and I apologize for anyone that went to law school, that we're bringing you back to property class as a 1L. Those are memories that you probably suppressed and don't really want to go back to too much. But it is important to just talk about the definition of a tenancy by the entirety asset. So number one is unity of possession. And what this means is that both spouses have control and joint ownership of it. It makes it difficult to do planning in some situations because of the fact that both spouses own the property and have control over the property. Specifically, and we'll touch on it later, if you're interested in trying to form a trust that would be owned as tenancy by the entireties, it's a little bit of a gray area. It's a very technical area. It's something that we would recommend making sure that you have reviewed by counsel to make sure that it is something they're comfortable with that does not blow the tenancy by the entireties protection. Because when you start talking about the control of assets on death and how assets will pass on death, that's what makes it more difficult. The unity of interest, that just means that each spouse has the same amount of an interest in the account, so each spouse could withdraw 100% of the account. The unity of interest does not refer to the assets going into the account, so it's acceptable that one spouse contribute all the assets to the tenancy by the entireties account. Once that contribution is made to the account, it's a tenancy by the entireties asset, and either spouse has full access to all the funds. It doesn't mean that the spouses have to put the assets in 50-50. Unity of time. This is the one that trips up a lot of people. And it sounds like it's a little bit of legwork. It is a little bit of legwork, but if you can fix something before a potential creditor situation is even on the horizon, and be sure that you own it as tenancy by the entirety, as opposed to potentially having an issue, I would rather do the little bit of legwork. And so what this is that if one spouse has created an account, and so let's say we open an account at the local investment bank, and I have it in my name, and I've decided after listening to this wonderful webinar that I would like to go and change the name to a tenancy by the entirety account, because my wife Karen and I feel better with that because of the chance, she's a better driver. She drives a lot more slowly than I do. It's a lot less likely that she's going to have a claim than I will. So let's put it in tenancy by the entireties asset. Let's get it out of my name. If I go down to my local bank and I take the account that's in my name and I say, I'd like to add my wife Karen to the account, and I'd like to switch this to a tenancy by the entireties account. If they just add Karen and they do some internal work at the bank, a creditor could claim that it's not a tenancy by the entireties account, because when the account was actually established, I was the only one established, which goes to that established the account, which is the unity of time issue. It's much safer for me individually, if I'm the client, or for you as a practitioner to recommend to clients that what they do is open up a new account. It can be at the same investment institution. I know if they have check writing on it, they're going to have to get new checks. If they have auto deposits, we're going to have to go through all that work. It's not fun, but if they open up a new account that's titled as tenants by the entirety, then it's clear that that's what the account is. And so what they can then do is transfer the funds that were in the one spouse's name, or in my example, in my funds, in my account, into the tenancy by the entirety account. And we should be good to go as far as having the protection going forward. So I just wanted to point out that one of my 3 dogs made an entrance into the room. Sorry that we're not on video, but she's the old lady at the house, and she gets to go wherever she wants to. So hopefully she'll be quiet and we won't hear any barking in the background, but that I can't guarantee. I think I have the kids interested enough on TikTok that they should still be good for probably the next 24 hours, but definitely for the next 15 minutes. So the other 3 items for the definition of a tenancy by the entirety: unity of title, ownership under the same title; survivorship, when one spouse dies, the other becomes the sole owner of the property, so you're not able to designate where the property would pass other than to the surviving spouse; and the unity of marriage, of course, that you have to be legally married under Florida law. And again, that is legally married. If you're reading older books, you'll see references to husbands and wives as tenants by the entireties. Just read that as spouses, as tenants by the entireties. One thing I'd like to point out is going back to the survivorship items of a tenancy by the entirety asset. And we'll touch on this in a little bit more detail going forward as well. If a husband and wife own an asset as tenancy by the entireties and the husband dies, the assets pass to the wife. The wife does have the ability to, or the surviving spouse, I should say, does have the ability to execute a disclaimer whereby he or she would refuse to accept the 50% ownership interest that she would inherit as a surviving spouse. And then that 50% ownership interest would pass through probate and fund the living trust of the first dying spouse in certain situations, assuming basic planning. So it's a situation where you can have the creditor protection during lifetime. You can still get half of the value of the assets into a creditor protected trust, assuming that the surviving spouse doesn't have a creditor situation at the time that the disclaimer needs to be executed when the first dying spouse passes away. And, further assuming that the documents are drafted appropriately for that. So it's an option that we have. We can talk about it in a little bit more detail. Nature and type of assets. Even if you're not going to be looking at tenancy by the entireties, if we're just talking about allocating assets between the husband and wife, two spouses, and again, I'm not sure why you wouldn't put tenancy by the entirety. That seems like the safest, most reasonable, easy thing to do for most of the assets. But just be conscious of the fact that if you have one spouse who is much more likely to have a creditor claim, that maybe you place more assets in the name of the spouse who doesn't have the potential liability. It's very easy to do. The protection's not as good as tenancy by the entireties. The protection's certainly not as good as combining tenancy by the entireties with a limited liability company or a limited liability partnership. But if you're looking for a quick fix, that might be the way to go. And that's just discussed a little bit more on this slide. So again, it's like most quick fixes in life. It's not the best option. It's just an option. And if it's the only option you have, it's better than nothing. If that's the only thing that the client will do, it's better than nothing. But at the same time, it's not as good as what you could have from a protection standpoint. So again, retitling in the low risk spouse is something simple to do. I did want to touch quickly on the LLC planning errors that we find. If you're familiar with some of the literature that our firm has produced, we've often had webinars on LLCs, how to maintain LLCs, mistakes that we find with respect to the maintenance of LLCs and or forms of LLCs, and how those impact the potential creditor protection that you have, and how they also would impact the potential estate tax savings that you have if you're using it as an estate tax savings vehicle for part of your planning. And so this was an article that Alan had written all the way back in May of 06. We've updated it, but I wanted to show you this slide because it shows that it's one of the most common mistakes that we see for over 14 years, and it's something to be very much aware of. Is that if you think that you have a LLC interest that's owned as tenancy by the entireties, you need to make sure that the operating agreement actually functions in a way that it doesn't violate any of those 6 rules that we talked about earlier. So if we looked at like provision B, a provision under the operating agreement that restricts the transfer, if one spouse doesn't automatically receive the interest on the death of the other spouse, that could mean that we violated the rules that we talked about. So if we go back, survivorship, number 5, definition of tenancy by the entireties, on the death of one spouse, the other spouse has to become the sole owner of the property. So if you have language in your operating agreement that prevents that, then even if the operating agreement states that the husband and wife or the spouses are owning the property as tenants by the entireties, they're not, or they potentially are not, because of the fact that they can't satisfy the 6 elements that we talked about earlier. So it's one thing to make sure of is that if you're relying on tenants by the entireties ownership of a membership interest in an LLC, whether it's voting or non-voting, or if you're relying on the tenants by the entireties ownership interest for a membership or a partnership interest in a limited partnership or a limited liability limited partnership. And again, it doesn't matter if we're talking limited partner, general partner. If you're looking for that tenancy by the entirety ownership interest, you need to carefully read the operating agreement to be certain that there are no restrictions in there that inherently cause a potential issue. And we have language in our operating agreements we'll be happy to share with you. One of the things that are in there is we do have a boilerplate clause at the back that, and notwithstanding anything here into the contrary with respect to any interest that's owned as husband and wife or by spouses as tenants by the entireties, that the following shall apply. And we also have modified our operating agreements that when we do have tenancy by the entirety ownership interest, some other language that we would have in there that we're concerned would violate the elements of a tenants by the entirety interest, that we've removed that language as well. So I encourage you, if you would like to see anything more either about the 8 steps or if you'd like some of the language that we're talking about here or any of the language that we'll talk about or any of the slides that you're interested in, just go ahead and send me an email and we'll be happy to go ahead and send that information off to you. A couple other items, stock certificates. It's a presumption of tenancy by the entireties, unless it's specified as something else. And then that's one thing that's important to think about. Now, before we get to tax reporting consistency, I would like to point out, and we've got material in here, but if we go back to the idea of the presumption that if I check the box for tenancy by the entireties, it's tenants by the entireties asset. If I have the option of checking tenants by the entireties or checking joint with right of survivorship, if I check joint with right of survivorship, I now own that with my spouse, joint with right of survivorship. What that means is that I don't have the protection that I would otherwise have under tenancy by the entireties. Same idea as if I check a box for tenants in common. I no longer own that asset as tenants by the entireties with my wife, and therefore, because I don't own it as tenancy by the entireties, half of that asset would be potentially exposed to a potential creditor that I would have, or a potential creditor that my wife would have. Whereas if I had selected the tenancy by the entireties box, then that would be a problem that's solved. So again, to focus on what we talked about earlier, if I have opened up an account at a brokerage account and I did not open it as tenancy by the entireties and I had the option to, I am going to open a new account with my spouse as tenants by the entireties, transfer the old funds in there. Now I've got a tenants by the entireties account nice and clean going forward. If you take away one thing from this webinar today, that's what you need to take away. All right. Now, if you are opening a bank account, so a lot of banks do not offer tenancy by the entireties because technically it would require the signature of both spouses on every withdrawal, every check, etc. So if the bank does not offer tenants by the entireties on the account, and you therefore own it as tenants in common or joint tenants, the court will assume that you intended to own it as tenants by the entireties. So it's Beal Bank versus it's a case that we have the citation to in a little bit. So there is that presumption there that if you don't have the option, they'll presume you would prefer to have the protection of tenants by the entireties. But if you did have the option and you picked one, the court's going to honor what you picked. So again, it's something that's extremely important when you're looking at it from a creditor protection standpoint. It's the same idea with the life insurance. If you don't have the beneficiary designation made payable to the correct trust, or if it's just payable outright to a beneficiary instead and it was a mistake, it's something that the devil's in the details. It's something that's very, very, very important to make sure it's done correctly, because the downside could be catastrophic. It's a little bit of legwork, it's a little bit of detail, but if you make sure it's done correctly, you're going to have a huge benefit for family, for the family, whether it's yours or your clients. Tax reporting, it's kind of a little bit of a gray area. According to the IRS instructions, TBE owners, should receive 2 separate K-1 forms. The problem with that is that it's a bad fact. If I own a tenants by the entireties interest in an LLC with my wife, we own 100%. My CPA gives me a K-1 for 50% and a CPA to Karen for 50%. It doesn't look like TBE because, again, TBE is 100% ownership by both of us. From our standpoint, it'd normally be better to just mark, that it's going to both spouses as tenants by the entireties. Have it be 1 K-1, assuming that the husband and wife are filing, or spouses are filing a joint return. Just have it as 1 K-1 to both of them, 100% as tenants by the entireties using one of their socials. With a joint return, it's not going to make a difference from an income tax standpoint. If they are in a creditor situation and you've got an aggressive attorney on the other side, I'd rather be able to show them that the operating agreements show the ownership is tenants by the entireties, and the K-1 clearly shows 100% tenants by the entireties rather than 50% to spouse 1, 50% to spouse 2. Again, it would not necessarily be controlling, but if you can avoid a bad fact, why not avoid a bad fact? All right, contracts to purchase real estate, just make sure that it's as tenants by the entirety. So when you make that deposit, the deposit, it might not be 100% clear that it's tenants by the entireties versus tenants in common. Just clarify with the addendum, or if it's not clear that it is tenants by the entirety. Something simple that you don't think about, but if you put down a significant deposit on a home and it's not your homestead, and then a creditor situation happens, again, it's something that easily can be addressed. Why not take it off the table as something that would be a concern, either whether it would make you lose a little bit of sleep later, or from a creditor protection standpoint, could be potentially an issue. One item to note U.S. Treasury bonds cannot be owned as tenants by the entireties. So there are certain assets that cannot be owned that way. This is one of the more prevalent ones that we run into. Tax refunds, it's a presumption basically under Florida law that if it's from TBE, that it would be TBE property, but you need to make sure that the refund does get deposited into a TBE account for that to be result to happen. Tangible personal property, physical non-real estate assets. So basically, if a tangible personal item is located out of the state of Florida, it may not be recognized as a tenant by the entireties asset because the situs of the tangible personal property may control. So if you're concerned about that, you can do a confirmation listing assets that they are owned as tenants by the entireties. Another option would be to have if you have personal items that are inside a home, maybe you have those assets owned by an LLC, have the ownership interest through the LLC again as tenants by the entireties. There's things that you can do to help clarify. For a lot of people, this isn't a significant risk, obviously, but if you do have valuable personal assets that are outside of the state of Florida, that's something you may want to be aware of and or consider, is that the situs of the local law could apply with respect to the personal property that you have there. Automobiles and vehicles, we normally recommend you do not want to have an and. So don't be husband and wife as tenants by the entireties. That's an example of where if you have assets that are owned as tenants by the entireties, and who could a joint creditor be? A joint creditor could be someone who just got hit when one spouse owns an automobile, or is driving the automobile, but they own the automobile as and husband and wife, as opposed to just husband or just wife. It might be a little bit more work if the spouse passes. Typically, you don't need to have a probate to get title to the vehicle. You're just able to go to the DMV with a copy of the will and a copy of the death certificate and get the title taken care of. But for the amount of protection that it affords, even if you had to have a little bit of hassle to get the title to the car after the first dying spouse dies, it's still worthwhile to take care of it. Real estate outside of Florida, we talked about that. Owning it through an LLC, and again talked about the idea that it needs to be an operating agreement that respects what tenants by the entireties is. A couple other points on tenants by the entireties, because it's just between husband and wife, and we live here in Florida, or between spouses rather, and live here in Florida, it's just a two-person account. We don't recognize multiple marriage, so therefore that's not going to happen. A couple other things to talk about are that the IRS can invade TBE assets where only one spouse owes the taxes because they are a super creditor. So if you're in that situation, realize that the ability to have the protection does not extend to that level. If you're investing in other real estate, consider the ideas for bankruptcy, etc. What we talk about on this slide is just the idea of trying to make it so that you're not both on a guarantee and or using a corporate structure to help limit additional liability. Joint revocable trust, it's a gray area. It's something that if you're trying to make a joint revocable trust and draft it correctly and still have it owned as tenants by the entireties, it's something that's extremely technical, and I would recommend making sure that you either personally are very comfortable with it or have someone review it with you or go over the document to help make sure that it appears that it would comply with the tenants by the entireties protection. If you have a typical joint trust that you've drafted just because the estate tax exemption is no longer a concern and you'd rather try and get a step up in basis on death of the first dying spouse of all the assets, and you want the simplicity of a joint trust, that joint trust typically is not going to allow for tenants by the entireties assets to be owned. So just be aware of it. Make sure that you go into the situation understanding that you're letting go of a little bit of the degree of asset protection and with a typical joint trust. Funding the bypass trust with TBE property, this is what we talked about. The surviving spouse can execute a disclaimer within time period after date of death, assuming that they haven't accepted the assets. And one half of the assets that would otherwise be owned by the spouse. So if my wife and I own $500,000 account as tenants by the entireties, I pass away, she would own $250,000, and she would have the ability to disclaim the additional $250,000 to the bypass trust. The other option is she would just have $500,000 individually. Now, if she does disclaim the assets to the bypass trust, you need to recognize she's not going to have a power of appointment over those trust assets, meaning that on her death, she won't be able to direct how they pass. They would just pass pursuant to the terms of the trust instrument, which typically would mean that they would pass to my 3 children in equal shares. But it is a way of getting assets into the protected trust structure for the benefit of the surviving spouse and descendants. Only half the value can go in. But what you need to be aware of is that, like we have in number 2, if the non-debtor spouse dies while the debtor spouse is in this situation, that spouse will not be able to execute a disclaimer to fund the trust. And more importantly, now that spouse no longer can rely on the tenants by the entireties protection, and the creditor now has access to an asset that's owned 100% by the one spouse as tenants by the entirety. That's why frequently what we would recommend is looking at forming an LLC. The LLC can be owned mostly, 95, 97, 98% by the spouses as tenants by the entireties, and can be owned the balance by an irrevocable gifting trust for the benefit of the children. While both spouses are alive, the trust would be ignored. The whole structure could be ignored for income tax purposes, so we wouldn't be generating additional tax returns. And if one spouse died in our situation, the surviving spouse who has the creditor claim now would have a membership interest in an LLC, but the LLC would have multiple members, so the creditor would only be limited to a charging order for protection purposes, meaning that they would only be able to receive any distributions that came out from the LLC. They wouldn't be able to force distributions from the LLC. And then at that point, then you're relying on the LLC law to help provide that additional creditor protection that's no longer available because of the first dying spouse. So again, the simplest route, it's always the easiest, but it's not always the best. There had been some concern that if I transferred assets from myself to an account for my wife and myself, that we needed to go through a straw man third party. That's no longer a concern. So it should be acceptable to have the assets move directly from my spouse's account to the 2 of us as tenants by the entirety, or vice versa. A couple of special items. We touched on all of these, but again, if you wanted just one slide to remember, here are some little things that just file away and trigger. So we're talking about tenancy by the entireties, and we're talking about real estate outside of Florida. I need to remember there's something here. We've got a kind of a 1-page list that you can have on your desk or on your desktop, showing the far left creditor exempt assets. These are the assets that are exempt from creditor claims. You'll see in there we have in the middle tenancy by the entireties. In the middle column are assets that are difficult for the creditor to obtain. So the top one would be the limited liability company interest, like we just talked about, having a charging order but not having access to the value of the assets. And then the far right are the assets that would be exposed to a creditor. So in our talk today, the far right would be the tenancy by the entireties account after one spouse has passed away. And unfortunately, the spouse that passed away is the one that did not have the creditor claim. So now I've got a surviving spouse with a creditor claim who now owns 100% of an account, and that's individual money on the far right that's now exposed. So again, looking forward, that's what we would talk about. We're not going to have time to go over it today, but I did want to provide you with some slides just showing how we would commonly structure assets between 2 spouses, using the Florida tenants by the entireties protection in the middle, also using lifetime and irrevocable gifting trust for the benefit of one spouse and or for the benefit of the children, and then adding the layer of the firewall planning with the LLCs. Again, if you are interested in this, we'll be happy to go ahead and send you any of the slides as far as what we have here if you want to have the material. So I just wanted to give those to you, and I did not have enough time to get through them, but I think they're pretty self-explanatory. And the last item that we'd like to talk about is that for any of the people attending the webinar today, if you'd like to talk about any of the topics that we talked about today for 20 minutes, we are making ourselves available, to clients and to practitioners to help with questions that they have. And we'll be happy to give you a free 20-minute call to discuss any of these items. So if that's of interest, feel free to send me an email. And when I receive that, we can go ahead and schedule a time to talk. So I hope you enjoy the rest of the day. I'm impressed that I got through 2 webinars without any dogs barking and without any children screaming. So the children have either all killed themselves or are actually behaving. So I'm going to go with behaving because I don't want to have to explain that one to my wife. And I'm going to sign off again with Alan's favorite line. If you're a working practitioner, may the rest of your day be billable. Thanks very much.